Consideration. It is important to note that the court will not enforce a contract unless supported by consideration. The law enforces bargains to which both parties contribute and not as a gratis promise. At the end of the lesson, learners should be able to achieve the following. What is consideration? Consideration is defined as given, done, or forborne by one party in return and must have legal values. According to Section 2, Clause D of the Contract Act 1950, it highlighted consideration as an act or abstinence should be done at the desire of the promisor, and it should be done by the promisee or any other person, has done or abstained from doing, or does or abstain from doing, or promises to do or abstain from doing something. And all this is called consideration for the promise. Let us look at the following scenario on how consideration works. Valid consideration is where both parties are giving and getting something out of the agreement. Say we have an agreement to buy a computer. The offeror will give the computer to the offeree. The offeror will give and the offeree will receive the computer. Then the offeree will give money for the computer, in which the offeror receives it. The consideration happens when both parties are giving and getting. Section 26 of the Contract Act 1950 highlighted an agreement made without consideration is void. What are the various rules governing the law of consideration? 1. Act of consideration is at the desire of the promisor. Section 2D states the act constituting consideration must be done at the desire or request of the promisor. Suppose there is no request by the promisor on the act and it was voluntarily done. It will be considered as a bare promise without consideration. However, an act at the desire of a third party is not a consideration. 2. Consideration may proceed from the promisee or any other person. In Malaysia, consideration need not necessarily move from the promisee. Although acceptance must be made by the offeree, it is not the case of consideration. Section 2D of the Contract Act 1950 enables consideration to move from any other person other than a promisee. A party to an agreement can enforce a promise even though he had given no valuable consideration. For example, in a construction project, the client will enter into agreement with the main contractor. However, the main contractor will then employ the subcontractors to execute the job. So as you can see, the consideration was being transferred to a third party. Now this dynamics can be seen in the case Venkata Chinaya versus Verikatara Maaya. Third, consideration may be future, present, or past. According to Section 2, Clause D, it states consideration can be in the form of done or abstain from doing, does or abstains from doing, or promises to do or abstain from doing. Hence, this is considered past, present, or future. Future consideration is when the promise comes first, followed by action. The consideration on both sides is moved at a future date. For example, X promises to sell and deliver 10 bags of sugar to Y for 500 ringgit after a week upon Y's promise to pay the agreed price at the time of delivery. The promise of X is supported by the promise of Y, and the consideration is executory on both sides. Present consideration is the consideration moves simultaneously between the promise and the action. A sells and delivers a book to B. Upon B's promise to pay for it at a future date, the consideration waiting from A is present or executed consideration since A has done his act of delivering the book simultaneously B's promise. Past consideration. Generally, past consideration is not a good consideration. However, if the past act done was at the desire of the promisor, then it is a good consideration. Example: A asked B for help to find his missing cat. After B had performed it, A promises to give B 100 ringgit. So, for past consideration, the action comes first, followed by the promise. This can be seen in the case Lampley versus Bradbury. Rule number 4. Consideration need not be adequate, but must have legal value. Consideration must be real and not illusory. Consideration has to be in some value in the eye of the law, but the court not concerned to its adequacy. Explanation 2 to Section 26 of the Act reaffirms that inadequacy of the consideration does not cause the contract to be void. The court will only look at the inadequacy in determining whether the promisor's consent was freely given. Refer to the case Thomas versus Thomas. On his deathbed, John Thomas expressed to his wife to have either his house or £100 or the other provisions in his will. After his death, the executors of his estate, Samuel and Benjamin, entered into an agreement with Eleanor, which is John's wife. The agreement stated, in consideration of John's desire, Eleanor will take possession of the house and in return maintain the house and pay only £1 per year for the ground rent. Eleanor remained in the house for some time. However, after Samuel's death, Benjamin refused to complete the conveyance, claiming that the consideration of £1 is lacking. However, according to the court, by agreeing to pay rent in return for being allowed to stay in the property, Eleanor provides consideration, even though it was not economically adequate or anything like a commercial rent for the building. Therefore, the contract was enforceable. Rule number 5. Consideration must not be a pre-existing duties. Where a party has a public duty to act, this cannot be used as a consideration for a new promise. Performing or agreeing to perform a pre-existing duties is not considered as a good consideration, unless the promisor goes beyond their duty. Refer to the case Stilk versus Myrick. Rule number 6. Part payment may discharge the whole obligations. Section 64, Contract Act 1950 provides every promisee may dispense or remit, wholly or in part, the performance of the promise made to him, extend the time, or accept any satisfaction which he thinks fit. The promisee may waive his rights to demand the performance which releases the other party from his obligation. It allows promisee to grant extension of time for performance. However, it does not entitle a promisee to extend the time unnecessarily. About accord and satisfaction, there must be a tender which is accepted as satisfaction of the debt due by the party in whose favor the tender is made. It can be illustrated in the case Kirpa Singh versus Bariam Singh. Rule number 7. Consideration must not be illegal or unlawful. A valid consideration must be made for a lawful consideration with a lawful object. Section 24 of the Contract Act lays down what consideration and objects are lawful and what's not. Section 25 provides that part of single consideration or part of a single object of an agreement is unlawful. Therefore, the whole agreement is considered void. Without consideration, there is no exchange of promises and no payment for good received. If you sign a contract that does not have consideration, it will likely not be enforced by the court. However, Section 26 of the Contract Act 1950 provides that an agreement made without consideration is void unless it falls within one of the 3 exceptions laid down in the section. 1. Agreement on account of natural love and affection. Clause A of Section 26 lays an agreement without consideration can be enforced if it is made and registered. It is made on account of natural love and affection, and it is for parties standing near relations. Natural love and affection is where affection is reasonable to be expected regarding the normal emotional feeling of human beings. Near relations refer to the parties and concerning the circumstances of the family concerned. Refer to the case Tan So Sim, Chan Lam Kyong and others versus Tan So Kyo and others, where the court held that the validity of consideration depended on natural love and affection between near relationship, and nearness depended on the group mores to which the parties belong and the particular family circumstances. 2. Past voluntary service. Clause B of Section 26 provides that a promise for something voluntarily done is enforceable. Application of Section 26B has to the service must be rendered in the past, it is rendered voluntarily, and the service is for the promisor and not for any other. Therefore, the subsequent promise to compensate wholly or in part. Exception number 3. Promise to pay a time-barred debt. Clause C of Section 26 provides that a promise to pay time-barred debt is enforceable if it is satisfied the following condition. It is made in writing and signed by the promisor. It is to pay whole or any part of the debt. And the debt must be such of which the creditor might have enforced payment but for the law for the limitation suits. A time-barred debt is a good consideration for a fresh promise to pay that debt. Example, if you have an old debt, collectors may not be able to sue you to collect on them. That's because that collectors have a limited number of years, known as statute of limitation, to sue you to collect. After that, your unpaid debts are considered time-barred. According to the law, a debt collectors cannot sue you for not paying a time-barred law. Therefore, if you intend to pay the debts, you may do so under Exception 3. Essentially, all agreements must be with consideration, where both parties are giving and getting. Consideration is essential to the formation of any contract made without deed. It is distinguished a bargain or contract from a gift.